I want to talk to you today about the court process when you're charged with an impaired driving charge. How is your case going to proceed through the court system? Well, this is a topic that we cover with a client in our very first initial intake when they're meeting with us and deciding whether to retain us. So first of all, you're basically given a court date about 3 to 6 weeks after your arrest. So the police will release you, they'll process you and give you that court date. And in the meantime, hopefully you've retained us or another law firm and you sign a piece of paper which is called a designation. And what that means is that you are hiring that lawyer. You do not have to go to court on that first appearance. Now, at that first appearance, the Crown is generally expected to provide your lawyer with all of the police reports. It's called disclosure. Once we have those documents, the lawyer's in a position to meet with you and carefully review to see if you have any defenses, any technical defenses, charter applications, and provide you with a legal opinion. Criminal law and DUI law boils down to this. You have to, as a lawyer, you have to analyze what are the client's odds of winning this case? Where on the spectrum does it lie? And what is the Crown offering? So, for example, if you have a good case to win and the Crown's not offering any deal, shall we say, obviously you're going to take that case to trial. If, on the other hand, your case is very serious and difficult to win, and you want to try and minimize the penalty as much as possible. So that's a discussion we have at that first meeting where we review the disclosure. Now, oftentimes disclosure is missing, or there's disclosure we have to order, and we get that before we can finalize our opinion. So this is called the remand process. It's like an intake court, and that can last 2-3 months in a DUI case, impaired driving case typically. We're reviewing the case. I'm meeting with the Crown to get their position and see if things can be worked out or whether we're heading to trial. At all steps of the process, we're going to keep you informed about where the case is heading, what our opinion is, but most importantly, what you want to do. That's your decision. It's not ours, but we will help you and guide you. Of course, there's Stream A ignition interlock in Ontario, and if you instruct us to enter an early guilty plea, we try and get that done as soon as possible because that's to your advantage to qualify for Stream A ignition interlock, which I talk about on another videotape. So let's assume for a second that you're heading to trial. So at the end of that 2 to 3 months process, most counties in the province are going to require what's called a judicial pretrial. That's a fancy term for a meeting with the judge where the Crown attorney, your defense lawyer meet with the judge and talk about the trial issues, talk about managing court time, how long your case is going to take, who the Crown are calling as witnesses, and to see if there's any way of resolving it. Obviously, if we were offered a careless driving offer because the Crown thought we had a decent case to win, we might consider that. So that's another reason to have the judicial pretrial, to talk with a judge. Now, the judge is not your trial judge. It's a judge who's managing the system, managing court time. So at the end of that process of, say, 3 months in, we're ready to set your trial date. Your trial date in Ontario is going to take place anywhere from, depending on the county, anywhere from 4 to 8 to 10 months in that range after the judicial pretrial. So we're already up to a year in before you have your trial date. And of course, at your trial date, we're diligently preparing ahead of time. We're filing any applications to win your case, which need to be done. Often those are called charter applications. And then we're preparing you to testify. We're preparing to cross-examine the Crown's case, and we're there to win. I mean, that's our goal and our job when we go to trial, and we have a consistent winning track record of cases we take to trial. So there it is in a nutshell. That's the short version, shall I say, of the court process for a DUI. You could be dealing with your lawyer from anywhere from 1 to 2 months up to a year or longer, depend whether you resolve the case by way of plea or hopefully the Crown withdraws your charge to the time you complete your trial. And typically, the average DUI trial in Ontario is probably a 1-day trial. If a more complex case, it may take 2. So there you have it. That's a summary conviction, impaired driving, timeline, and the court process for impaired driving.